It seems South Korea and Japan differ on their interpretation of the 1965 treaty. How would legal experts from a third party view the situation? We have Timothy Webster, Associate Professor of Law at Western New England University, joining us via Skype. Welcome to the program, Timothy.
Hello, delighted to be here, and I'd like to thank Arirang Broadcasting for the opportunity to appear today.
We are grateful for your presence as well. Seoul's top court made the ruling last October based on the idea that the forced labor victims have individual rights to sue Japanese firms for compensation. In spite of signing the treaty, does a nation have the authority to prevent individual rights to reparation?
When people have brought similar World War II era claims in the United States, for example, or in France or in Germany, those courts have decided that the individual right to seek reparation was resolved due or when the treaties were signed between the two different countries. There's also a decision from the International Court of Justice called the Jurisdictional Immunities case that came down in 2012, where an individual Italian sued the German government, and the ICJ said sovereign immunity, meaning Germany is immune from such claims, means that the individual right to reparation cannot be recognized. So when you look at cases that are most parallel to the Supreme Court decision from South Korea, I think most courts would say that countries can do this and countries have done this. Now, it may be possible to look for an individual right in other fields of law. Right, so we're talking specifically about the issue of humanitarian law, the law that applies when war is ongoing. But if you look at other areas of law that might be at stake here, for example, international investment law, right, because you have Japanese corporations investing in Korea. If you look at international human rights law, I think you will see greater acceptance of this idea that an individual has the right to seek reparations from a government. So, as with all things in the law, there are different interpretations you can use that will help one cause or hurt a particular cause.
Right, and Japan said it wants to take the conflicting interpretation of the treaty through the International Court of Justice. Have there been cases where two sides got into legal dispute by understanding the agreement differently? And how likely is it that the ICJ will handle this particular case?
Sure. So I'll respond to that in a couple of ways. First of all, the International Court of Justice only hears cases between two countries, right? And in this particular case, the Supreme Court forced labor decision, we have Korean citizens and Japanese corporations, neither of which is a state, right? So in the typical ICJ case, you have Korea and Japan, or America and Canada, or Germany and Italy, two countries litigating against each other. The other way of responding to this is to talk about that decision I just mentioned, the Farini decision, where the International Court of Justice looked at a case similar to this and said, again, it wasn't completely the same. It was an individual against a state, right? And those are different. Those are different kinds of cases.
Professor Webster, should South Korea and Japan take this matter to the ICJ? What are the steps of the dispute settlement?
Sure. So the first thing that would have to happen is South Korea would have to agree to it. Now, the way the ICJ works is every country can decide whether it wants to appear before it, and every country has the sovereignty to decide, yes, I will, or no, I will not. As it is right now, some states have agreed to what they call, the mandatory jurisdiction of the court. So Japan has already said yes. Right, and many other countries have already said, yes, we agree to this. But other countries, including both South Korea and the United States, have not said yes automatically. And they will say, well, we will appear on a case-by-case basis. Right, so even though Japan has said yes to this by virtue of signing on to the mandatory jurisdiction clause, South Korea has still not done that. So South Korea would still have to decide whether it wants to bring this case before the ICJ.
All right, Professor Webster, thank you for sharing your insights on the matter. We appreciate it.
Well, thank you for the opportunity to appear today. I really learned a lot and look forward to having more conversations with you in the future. Thank you.